Hello dear students, welcome to my channel all about law. Today I will be explaining you the topic dissolution of partnership firm. Again, this is a very important concept under the Indian Partnership Act 1932. When we talk about dissolution of partnership firm, then students often get confused between dissolution of partnership and dissolution of partnership firm. Dissolution of partnership is also known as reconstitution of the firm. In my previous video, I have already explained you about dissolution of partnership, that is reconstitution of the firm. Whenever there is any change in the relationship of the partners due to admission of a new partner, retirement of an existing partner, change in the profit sharing ratio, death of a partner or insolvency of a partner, then basically it is known as dissolution of partnership or reconstitution of the firm. In all these cases, the business of the firm continues. Okay, important here is that the business doesn't shut down. The firm continues, only the relationship changes. That is why it is known as reconstitution of the firm or dissolution of only partnership. But today we will be understanding what is the meaning of dissolution of partnership firm. Now we know that dissolution means termination or end. Okay, it means completely breaking up or complete termination. When we talk about dissolution of partnership firm, it means dissolution of partnership between all the partners. Okay, most importantly, yes, their relationship also changes, but the business of the firm also shuts down. Okay, the firm is completely stopped, assets are realized, liabilities are paid off, all the expenses are met, and surplus, if any, remains, then it is distributed among the partners. So basically the firm liquidates, okay, and there is a complete shutdown of the partnership firm. That is why it is known as dissolution of partnership firm. Now, winding up and dissolution, these two terms are also used interchangeably. So let me make you clear what is the thin line difference between winding up and dissolution. Now see, winding up is the former stage while dissolution is the latter stage. Okay, winding up means when basically the assets are being realized, the assets are being sold. Whenever any business has to be shut down, then what will be the first thing that is done is assets, if any are remaining with the firm, it will be sold. Okay, liabilities will be paid out from those realization receipts, expenses will be paid, and the surplus will be distributed. So when this phase goes on, it is known as winding up stage, winding up phase. Okay, and after the winding up, when there is a complete full stop on the business of the firm, when the registrar removes the name of the firm from its register, it is known as dissolution. Okay, so winding up and dissolution, these two terms are although used interchangeably, but there is a difference. Now, when we talk about dissolution of partnership firm, so there can be various reasons, various modes of dissolution of partnership firm. There can be various reasons. So let us understand what are the various reasons of dissolution of partnership firm, or what are the various ways of dissolution of the firm. As you can see, when we talk about dissolution of firm, there are two main modes, two main reasons. Okay, first mode is voluntary winding up, that is dissolution of the firm without the order of the court, without the intervention of the court. And second is dissolution of the firm, winding up of the firm by the court's order. Okay, so in first case the court has no interference, while in the second case of dissolution the court passes an order of dissolution and only then the dissolution comes into effect. So first let us discuss the various modes of dissolution of partnership firm without the order of the court, that is voluntary winding up of partnership firm. First is mutual agreement. Now, whenever the partners decide among themselves mutually that they want to shut down the business, either due to continuous disagreement or continuous differences of opinion or breach of trust or any other such issues, when the partners are mutually coming up to a conclusion that they want to shut down the business, they can do so, and if the partnership deed allows them to do so, they can voluntarily wind up the business of the firm. They can shut down the business of the firm. Second is compulsory dissolution. Now, when we talk about compulsory dissolution, there are two cases under compulsory dissolution when the firm will dissolve compulsorily. The partners don't have any choice in that. Okay, even if they don't want, the firm will definitely dissolve. So what are these two cases? First is insolvency of all the partners except one partner. If in any partnership firm, except one partner, all the remaining partners become insolvent, then it will become difficult for the partnership firm to carry on the business, because we know that in a partnership firm, the liability of partners is unlimited. Therefore, if all the partners except any one partner are insolvent, only one partner is solvent, that is all the partners except one have become bankrupt, then in that case, the firm will shut down. And the second case under compulsory dissolution is business becoming unlawful. Due to change in law, change in legal environment, change in legal circumstances, the business of the firm that was earlier legal has now become unlawful, and in that case, the firm will compulsorily dissolve. Let's move on to the third, that is on the occurrence of contingencies. Under this, again, there are two cases. In case of partnership for a fixed term, or when the partnership is for a particular project. Say suppose if the partnership has been executed for completion of any adventure or completion of any project. So and as soon as the project completes, the firm will dissolve. Okay. And if the partnership is for a fixed tenure, say suppose the partnership was executed for 5 years, then after the completion of 5 years, the firm will dissolve. Okay. No intervention, no court's order is required in this case. Let's move on to the last one under voluntary winding up, that is by notice. In case of partnership at will, we know that there are various types of partnerships. If you want to check out the video on the same, I'll share the link. You can go and watch that video as well, in which I have explained about various types of partnerships. Okay, so in that case, when the partnership is at will, in that case, any one partner can give the notice, okay, that he or she wants to dissolve the firm, and the other partners will have to accept the notice and they will dissolve the firm. Now, whenever there is partnership at will, or whenever there is any kind of partnership, all these clauses are being mentioned in the partnership deed. Okay, if I am talking about partnership at will, then definitely in the partnership deed it is mentioned that any partner, by giving a notice of dissolution, notice of his intention to dissolve the firm, other partners will have to accept the same and the firm will dissolve. Okay, so it is not something that comes suddenly. It is always mentioned under the partnership deed. It is better to mention. Okay. Now, let's move on to the second broad case of dissolution of partnership firm, in which court is involved, in which only the court can order the dissolution of firm. Partners voluntarily cannot dissolve the firm. So basically, when we talk about dissolution of the partnership firm by the order of the court, then a petition is being filed to the by the partners, okay, to the court for dissolving the firm. And if the court is satisfied, then an order is passed for dissolution. So first in this case is insanity. If any of the partner becomes insane, lunatic, okay, of unsound mind, then if suppose there are only two partners and one partner has become lunatic, so the other partner who is of sound mind can submit a petition to the court for dissolution of the firm. Okay. Then comes permanent incapacity. If any of the partner becomes permanently disabled, okay, permanent disabled, there should not be any partial disability, permanent disability, bedridden, not able to take any decision, okay, mentally he or she, mentally and physically he has become challenged and he cannot carry on the business of the firm efficiently. In that case, the other partner who is capable of carrying on the business can request the court, file a petition to the court for dissolution of the firm. Then comes misconduct. If any of the partner is involved in any kind of fraud, okay, if any kind of misconduct, any type of breach of contract continuously, then in that case, the other partners can take an order from the court for dissolution. Then comes breach of agreement. Now we all know that whenever there is a partnership, then a partnership deed, a contract is executed among the partners that binds all the partners, okay, and they are bound to perform as per the clauses, as per the conditions mentioned in the partnership deed. They have to follow the contract. But if any of the partner is consistently breaching the contract, okay, consistently contravening the provisions of the partnership act or the partnership deed, okay, violating the provisions, then in that case the other partners may file a petition to the court for winding up the partnership firm. Then comes next, transfer of interest. If any of the partner transfers his share of interest in the partnership firm to any other person, and that too without the consent of other partners, then in that case again court may order for dissolution of the firm. Then comes perpetual losses. Quite obvious and evident that if any firm is continuously in every financial year suffering losses and there is no scope, the partners find no scope, partners are of the opinion that no, this cannot be made a profitable one, this business cannot turn into a profitable one, and the business has become loss making, then obviously there is no sense in carrying on the business. So in that case the partners may file a petition to the court, and if the court is satisfied, the dissolution of the firm will take place. Then comes last but not the least, any other just and equitable ground. So apart from all the reasons that we discussed right now, if the court is of the opinion that no, any other justifiable ground is present, okay, there is a valid reason for ordering dissolution of the firm, then the court has the authority, court has the power to pass an order for dissolution of that particular firm. Okay, so this was all about dissolution of partnership firm in which the business of the firm shuts down. I hope you understood the topic well. Thank you so much for watching the video. Till we meet again, happy learning.